Hearing in the appeals, Queen on the application of Kiarie and Byndloss and the Secretary of State for the Home Department.
Yes, Mr. Chairman.
May it please the Court, in this case I appear together with my learned friend Mr Marcus for the appellant Kiarie. My learned friend Mr Gill, Queen's Counsel, Mr de Mello, Mr Newman and Miss Smeaton appear for Mr Byndloss. Michael Fordham, Queen's Counsel, Sonali Naik and Mr Hoshi appear for the intervener bid. Lord Keane, Queen's Counsel, Lisa Giornetti, Queen's Counsel and Neil Sheldon appear for the Secretary of State. My lady, I think that Mr Gill has one matter, procedural matter to mention before we get going.
My lady, there was the issue of the anonymity in relation to the children and their mothers. I know full well that in respect to Mr Byndloss himself, because fortuitously the way things happened at the permission hearing, the judgment was released without there being any anonymity and it ended up on Bailey. That I can't ask for anonymity in relation to him, but in relation to the children, and specifically naming them, and in relation to their mothers, I would ask for an appropriate order.
Of course, Byndloss is quite an unusual name.
It is.
So it may not be as useful as it otherwise would be, but we are where we are. So is there any objection?
We should.
We will make the usual order in relation to all the children and each of their mothers.
I'm grateful, my lady.
Thank you.
My lady, my lords, this is of course my appeal from the decision of the Court of Appeal, which granted permission to apply for judicial review of the certificate under section 94B issued in my case, but dismissed the application, retained the application for judicial review and dismissed it on the basis that although there was a misdirection in the guidance and in the issue of the certificate, there was only one answer to the statutory question posed by section 94B. And I propose to deal with the matters basically by addressing first of all the submissions we make on procedural fairness, the content of Article 8, an answer to the Secretary of State's submission on the distinctions between Article 8 and Article 6 in this context. Secondly, by dealing with the proportionality issue, and thirdly, by dealing with the issue of the role of the court and whether this is a case to which the Connors and Pinnock line of authority applies. The last two sets of submissions, although they raise substantial grounds, substantial issues, are fundamentally set out in our printed case, as indeed is the other one, but I propose to deal with that relatively shortly by reference to what we have said in the printed case. So it follows that the first part of my submissions are going to be concerned with the procedural fairness issue. And can I do that by taking the court, first of all, to section 94B, which the court will find at Volume 1 of the Authorities Bundle, tab 12, memory stick number 258. And no doubt the court is familiar with this section, but it is worth just taking it slowly. Subsection 1 provides that the section applies where a human rights claim has been made by a person who is liable to be deported under Section 3(5)(a) of the Immigration Act 1971, which is the power that was in play in our case. The certificate also applies where the deportation order was made under 3(6) by a court. Subsection 2 provides the Secretary of State may certify the claim if the Secretary of State considers that despite the appeals process not having been begun or not having been exhausted, removal of P to the country or territory to which P is proposed to be removed, pending the outcome of an appeal in relation to P's claim, would not be unlawful under Section 6 of the Human Rights Act 1998, public authority not to act contrary to the Human Rights Convention. And then subsection 3 provides the grounds upon which the Secretary of State may certify a claim under subsection 2 include, in particular, that P would not, before the appeals process is exhausted, face a real risk of serious irreversible harm if removed to the country or territory to which P is proposed to be removed. So I'll just highlight some elementary and basic features. First of all, the issue for the Secretary of State under subsection 2 is whether removal would be unlawful. There's some considerable consideration in the Secretary of State's printed case of the relationship between the certification power and the concept of an effective remedy. We say that the Secretary of State is not certifying whether the domestic scheme provides an effective remedy as a whole. The domestic scheme as a whole provides an effective remedy. The certificate is aimed at removal, and the fact that the certificate may be quashed if it's issued on a wrong principle and removal is prevented is irrelevant to the certification issue. Secondly, the certificate is issued at a very early stage. The Secretary of State, and according to the court, are looking forward to the likely conduct of the appeal. If she doesn't know, the Secretary of State, doesn't know whether removal will breach Section 6, she cannot certify. Cannot form a state of mind which considers that removal will not breach Section 6 of the HRA. If she doesn't have the information to form a positive view that removal will not be unlawful, she cannot certify. Alternatively, if she wishes to certify, she will have to obtain the information necessary to enable her to form a view. Thirdly, highly materially for these two appeals, one of the ways in which removal would be unlawful is that the removal will breach rights under Article 8 of the Convention. And there are two aspects to those rights. The procedural aspect, as Article 8 guarantees a fair procedure, using that shorthand for the moment, and also the removal for the duration of an appeal process will raise an issue about a potential substantive breach of Article 8. The early history of this provision was bedevilled by a view expressed in the Secretary of State's guidance that the critical issue was that raised in subsection 3, whether or not removal would mean that P faced a real risk of serious irreversible harm. But by the time the case was actually argued in the Court of Appeal, not throughout its preparation, that issue had fallen away, and it's common ground that the central issue is that raised by subsection 2. Part of the background to the case, to this statutory provision that is necessary to bear in mind, is that the Secretary of State has power to certify a claim as clearly unfounded. And the court will find that power in section, as it's in the form which is relevant to my case. In memory slip page 245, section 94, And the court will see subsection 2 is the operative subsection, which provides that a person may not bring an appeal to which this section applies in reliance on section 92(4)(a) if the Secretary of State certifies that the claim or claims mentioned in subsection 1 is or are clearly unfounded. So it is a necessary part of the factual situation we're considering that my client has an arguable case. It is not clearly unfounded, because no certificate so evidently has been issued under section 94. That is important, obviously, for both the procedural aspects and the substantive aspects, because procedurally one would expect to be finding a procedure which enabled the question of whether or not the arguable case is in fact correct, and a necessary factual exploration of all the ingredients in such an arguable case to be properly and fairly examined. And in a nutshell, our procedural case is that if my client is not in this country and not present at the appeal, that cannot be done, or certainly cannot be said to be clearly done, but said at the outset to be clearly done. And secondly, if one is looking at the proportionality of the removal, we have to approach the matter on the basis that the removal may well be temporary. The arguable case may turn out to be good. And so that what has to be proportionate is the temporary removal of an appellant in my client's position from the UK, while on the Secretary of State's case, he makes good the proposition that his permanent removal would be a breach.
Mr. Drabble, in saying that removal may well be temporary, are you trying to have your cake and eat it because you're relying also on statistics, which seem to indicate that out-of-country appeals really never succeed?
Well, there's obviously, I mean, the answer I'll give straight away to your lordship is that there's a relationship between the procedural limb and the substantive limb. I would say the Secretary of State is trying to have his cake and eat it. He says...
But my question was whether you were.
Well, why not? The answer may be yes. I'm not going to really demur from that proposition. I say straightforwardly. Just finish the sentence. And then I say straightforwardly the procedure is unfair. And I do also say that the statistics demonstrate that out-of-country appeals almost never succeed. And there are a load of judicial dicta to the effect to dealing with how poor the protection given by an out-of-country appeal is. I'll take your lordship to that. If, however, the Secretary of State is right about what he says about the effectiveness of an out-of-country appeal, or if, however, there is a category of cases in which the appeal may succeed and another category of cases in which the defects of the procedure will make it impossible, then you have to, the court, and my argument, have to cater with the fact that the removal may well tend to be temporary. And I wasn't going to do it now, but rather later in the morning, I was going to show the court the Secretary of State's current guidance. Your lordship will understand the guidance has shifted. But that tells the relevant officials to proceed on the basis that removal will be temporary. That's the basis on which the assessment of human rights is, they are instructed to carry out the assessment of the human rights issue. And we'll see, you may have seen the way we put it in the printed case, so I'll go back to it, that on the proportionality issue, it therefore is, the issue is whether a temporary removal is proportionate. My lady, I'm sorry. No,
it's all right. You've more or less said what I was going to say.
Good. So, can I then try to make good our vision of the appeal hearing that we say would take place absent the certificate? Because the Secretary of State, in his printed case, If we look at the printed case in the core volume at memory stick number 6776, paragraphs 88 to 90, sorry. What the Secretary of State says in those two paragraphs is, first of all, in paragraph 88, that appeals against entry clearance refusals make up a significant proportion of out-of-country appeals. Many of them will raise human rights issues, in particular as regards Article 8. Whilst they are concerned with entry rather than removal, in terms of procedural effectiveness, such an appeal has many similarities in the to the present context. Like deportation appeals, entry clearance appeals may require consideration of the impact of separation both on the appellant and on family members in the UK. In both contexts, the appellant can elect to have the appeal determined on the papers or by way of a hearing, and so on. And then there are other comparisons. 89 comments on the fact that the Strasbourg Court has not suggested the ability to give oral evidence is a necessary ingredient of an effective remedy. We'll come back to that when we consider the Strasbourg case law. And then 90 says, indeed, it is explained by reference to my client's case below, it's unlikely that the issues raised in a deportation appeal brought by a foreign criminal will require live evidence for their fair resolution. Nature and extent of the foreign criminal ties to the UK, including its length and residence in relationship with family members, is rarely in dispute. And he goes on to say it's usually the evidence of the partner that is most significant in resolving that dispute. The critical and determinative question is whether the interests of the foreign criminal and or any affected family members are sufficient to outweigh the public interest in deportation. That resolves to a matter of judgment for the tribunal and very rarely turns on issues of disputed fact. Now, I submit straightforwardly that that description of what happens at deportation appeals in paragraph 90, that it does not turn, or very rarely turns, on the live evidence of the appellant, is a description of a series of appeals which those on our side do not recognise. I'm instructed, and Mr. Keane would no doubt take instructions on this, that in all criminal deportation cases, the Secretary of State at the moment asks for an oral hearing. He has a choice, or she has a choice, but she asks for an oral hearing. A critical issue in many criminal deportation cases will be the evidence that the appellant gives about his propensity to reoffend. He will be cross-examined on that. Others who give evidence related to that issue will be cross-examined on that. Another issue will be integration into the UK. He will give evidence about that. He will be cross-examined about that. And similarly, members of his family or his friends or his community will all give evidence related to that sort of issue. And they will be cross-examined by the presenting officer or by counsel for the Home Office about that evidence. Later on, I'll come back to this, I mean, hopefully not at any great length, but later in the submissions. The Secretary of State's submission is that you can deal with this species of appeal by the appellant providing witness statements, which summarise his basic approach, from abroad, which go in, which presumably, on the Secretary of State's view of the world, are not cross-examined on. So the rhetorical question immediately arises, are they accepted at face value? How do you deal with any statements of fact made by the appellant, which the Secretary of State does not accept, would not accept in a live oral hearing? With respect, answer comes there none to that rhetorical question.
It's a pity we don't really have a view of the tribunal on all this, do we? Or maybe we do.
Well, we have There was some rather peculiar material. I don't know whether your lordship has...
Well, I was aware of the peculiar material, and I was rather excluding that.
We have a fairly recent pronouncement by Mr. Justice McCloskey, which I'll take your lordship to, which isn't in a criminal deport situation. It's in a different situation, but expressing extreme doubts, if I can put it like that.
We'll come back to it, but one of the things that occurred to me reading all this was that actually it might have been better if the upper tribunal had granted permission and had a hearing at which one could have looked at these matters and possibly got the president of the first-tier chamber to sit. The sort of thing one can do in the tribunal, and actually try and get someone from the department to explain how they think it's meant to happen, because it's quite difficult for us to do it at this level.
Yeah.
But maybe...
Well, I accept that.
One ultimate option for us, I'm not saying we would get there, might be to say, would it better go back and they can sort it out there. But anyway, I throw that into the mix because it does seem to be the upper tribunal would have been rather better equipped to evaluate these sort of issues than possibly we are.
Yeah. Well, I accept we have no straightforward evidence from the upper tribunal or indeed the tribunal system. We do have the views on the effectiveness of out-of-country appeals of, for example, I was going to take your lordship, my lady, to this later, but Lord Justice Sullivan, who was, I think, at the time president of the tribunal system, about saying that out-of-country appeals were much less effective. We do have the views of Mr. Justice Blake in Georgia about the importance of live evidence in assessing risk. And so there are a number of reviews of Mr. Justice Collins, who has considerable experience of the tribunal system, about the effectiveness of out-of-country appeals. So there's quite a lot of material to make good, on which I can make good, I think, my submission that when it comes to assessing risk, propensity to re-offend, degree of integration, matters of that sort, evaluation of live evidence.
Yes, I was more thinking, that I can see, we got the statements on that, but the question of how practically you can deal with that. Does video conferencing work? Who's going to pay for it? How can one... all those sort of practical issues which in a way, are implicit in what the Secretary of State is saying, but we really don't know quite how they would work in practice.
With respect to the Secretary of State, I don't think they are implicit in what he's saying. He is not saying that in a large number of cases there will be video conference. I will be corrected if I'm wrong about that. But
you're saying you don't need it?
He's saying that in the maybe rare case, I'm paraphrasing, and no doubt he can put it the way he or she put it, getting myself tangled up, his client's case in whichever way he wants to put it. But the way I'm going to present the procedural fairness aspect of it is that there isn't a case that in the routine sort of appeal there will be available video conferencing. We do not know of a single appeal which has been conducted using video conferencing. I'll show your lordship and my lady the material in a moment. But it's not as if the Secretary of State is pointing, well, there are kind of 50 a year which are using video conferencing. We haven't got anywhere near there yet. And we can see there's a case called Nair in which Judge Ockleton gave some guidelines about when video conferencing will be available. And I would take your lordship to all that material. That it's perfectly consistent with the thrust of these submissions. So, the Secretary of State's case is that case is and has to be, against the background of what I've just said, that these issues can be satisfactorily dealt with by written statements from the appellant which are not cross-examined on, and statements from his family, friends, members of the community, and so on, which are cross-examined on in his absence. And we say that's just a fundamentally unfair procedure. Our view of what the procedure involves is set out in some of the background evidence. If your lordships and my lady go to the witness statement that's put in on behalf of BID, if I can trespass on their territory just for a moment, in the core volume, at page memory stick number 6830. Paragraph 32 is addressed to the alleged parallel with out-of-country appeals in entry clearance cases. And this is a witness statement of Pierre Maclouf. And in paragraph 32, he says, in our view, there can be no appropriate comparison between an out-of-country deportation appeal and an out-of-country appeal for a person who is being refused entry clearance. An out-of-country deportation appeal ruptures the status quo in terms of private and family life, whereas an out-of-country entry clearance appeal maintains the status quo. In an entry clearance appeal, the documentary evidence will typically emanate from the country in which the appellant is present, whereas in a deportation appeal, it will typically emanate from the UK. Entry clearance appeals tend to be straightforward because there are prescriptive evidential requirements, and so they rarely require any evaluative assessment of all evidence. By contrast, in-country deportation appeals routinely are several hours and sometimes days, and require careful assessment of matters such as the appellant's credibility and the nature and quality of his or her private and family life. In our experience, significant weight is placed by the tribunal on its assessment of the evidence of witnesses in reaching findings of fact. Skype or video link impedes assessment of overall demeanour and prevents a very significant obstacle to taking instructions immediately before and during a hearing.
Mr. Drabble, on a tiny point, I think you said this was a Byndloss document. In fact, of course,
No,
Mr.
bid.
Maclouf.
Bid.
I meant
Oh, a bid.
I certainly meant to say bid. I don't.
see. You did. I'm sorry.
I can't say what I did
Yes,
say.
precisely.
Perfectly
What's
typical
the
of me to
Did
have
say
said
bid.
Sorry.
What is the state of it? This is a very recent document, isn't it? Now, last month, came about 3 weeks ago.
The witness statement, yes.
Yes, and it's got some very sweeping statements in it. So it's come in very much at the 11th hour. I imagine that for there to be a detailed reply by the Secretary of State would take quite a considerable time. I mean, what are we to make of this document?
Well, in the generality, I make no submissions about it. The only submission I want to make is that paragraph 32 is consistent with evidence which has been in front of the Court of Appeal.
Right.
There were, I don't know whether your Lordship has picked up, there were directions under which evidence was prepared for and lodged in the Court of Appeal.
Well, that's precisely what I had in mind.
Well,
This wasn't part of it. This is I think,
I fully accept this particular...
Fordham will no doubt speak to it in due course. But
Yeah, I'm quite sure he will, but the material I'm just about to go to is entirely consistent with this. The relatively simple point is that entry clearance will very often be assessed by the entry clearance officer and subsequently by the tribunal against the sort of criteria set out in the points-based system. I mean, it is...
Yeah.
It's
that particular paragraph sort of summarises stuff we've got elsewhere.
Exactly.
I mean, I think there is a question in my mind, my lady will obviously, about, we certainly gave consent for submissions, I think. I don't know that we gave consent for...
And if you're criticising the Court of Appeal, which you are, and saying that it reached wrong conclusions about the real value of an out-of-country appeal, for my part, it would be more helpful to look at the evidence which was before the Court of Appeal.
Well, I'll do that now. Yes, I possibly created unnecessary diversion by going into the bid material. My submission, I could make the point myself that there's a difference, or fundamental difference of character between an entry clearance appeal and a deportation appeal, which all the material demonstrates. And a great deal of the defence of the Secretary of State is on the basis that there is no such difference, that the acceptability of entry clearance appeals demonstrates the acceptability of the out-of-country deportation appeal. Now, the other material, if I can go on to it then, Mr. Sharma's third witness statement, which was in front of the Court of Appeal, is at Appendix 5, page 1309, and I think that's manuscript number 8169. Let me just make sure that's right.
Did you say 8169?
8169. The witness statement starts at 8169.
It does.
And it's 8175. I'm told that I am working off paper and I need to find 1309. Wrong volume. And it's paragraphs 20 and 21, so we're working on paper 1309 and 1310. And he's replying to Mr. Welsh's statement on behalf of the Secretary of State. Equally, in relation to paragraph 38 of Mr. Welsh's statement, whoever has made the quoted observation cannot have had in mind a Section 94B deportation in the impact it will have on affected children. A comparison with out-of-country appellants, i.e. entry clearance cases, completely misses the point about a Section 94B deportation. Neither I nor any of the many immigration practitioners, including counsel with whom I have consulted in the preparation of this appeal, has ever come across a single criminal deportation case in which the Secretary of State has agreed any of the facts.
That's a very large statement.
It is a very large statement, and probably, not, well, with respect, probably not true, but it is certainly a case on my...
Any of the facts?
Yeah, any of the facts is a large statement. The first factual issue, which is always in dispute, is the of individuals' risk of reoffending and the risk posed to the public. This is never agreed. The second factual issue, always to be in dispute between the parties, is the content and strength of the family relationship and wider social connections. None of these facts are ever formally conceded by the Secretary of State, certainly never prior to the appeal hearing.
So it's not so much any of the individual facts, it's the factual issues that aren't agreed.
Yeah. Yes.
It's the inferences to be drawn from the facts, yes.
I suspect it's both, but...
Well, over the page,
over the page. Often an individual's relationship with children, the extent to which he or she may or may not have involvement with children or provide care or involved in day-to-day care of them, is never agreed. It's always left to the appellant to persuade the tribunal judge as to those facts. In doing so, it's vitally important for the reasons I set out at paragraph 4 of my second witness statement, that evidence is given in the judge's presence where he or she is able to assess not only the words that are said, by the manner in which the evidence is given and associated facial expressions and body language. It's not just a question of hearing the words. The ability to observe a witness's demeanour and deportment during the giving of evidence is important, and in my view essential to assess accuracy and credibility. It's about seeing the face engaging the reactions, about assessing the sincerity of body language. In my experience, often mannerisms convey emphasis and portray sincerity more powerfully than simple words. This is more so the case when appellants do not speak English as a first language. The ability to make findings on fact taking into account the full range of assessment tools assumes a greater level of importance in children cases where if the decision is upheld, it will result in a breakup of the family unit. Now that statement is mirrored by a statement of my instructing solicitor, which is in his second witness statement, Appendix Part 5, page 1183, memory stick number 8049. And it's paragraphs 6 to 14, so that they are at 1184, 1185. And he says, under the heading Views of the Tribunal, which is a reference to the materials that did emanate from some tribunal members and was subject to some criticism, in paragraph 6, he says, in his statement, Mr. Walsh refers to the responses he's obtained from the tribunal. The responses touch upon consideration of the credibility of an appellant in out-of-country appeals, confirming that this is not a new issue. In my experience, the application of credibility findings in deportation cases is completely different to those in the majority of out-of-country appeals. As illustrated in the ECO cases referred to by Mr. Welsh in his exhibits, issues in those cases often focus on the credibility of the sponsor rather than the appellant. In a deportation case, it's the appellant's behaviour, relationships and conduct which is under scrutiny. Put simply, it's the appellant themselves who are being judged. In my experience, the evidence of an appellant in a deportation appeal, which includes the way he presents himself and responds to cross-examination, is often central to the findings of the tribunal. This is due to the focus, which I believe is unique to deportation appeals, on the past and present conduct of the appellant. Then there's a reference to statistics, and then the comment on the views of the tribunal state that the absence of an appellant in an ordinary case would not cause any real disadvantage, where in Article 8 is based on the separation from other family members. Those family members will be able to give evidence. This analysis can often, but not always, be correctly applied to the ECO appeals referred to by Mr. Walsh. But what it fails to appreciate is deportation appeals, for the reasons already set out by Mr. Sharma, are very different to your ordinary case. And then he deals with video links. Mr. Welsh states that video link facilities are available in the tribunals across the UK. My understanding from having spoken to practitioners with experience of having attempted to use video link conferencing in their appeals is that whilst video link is available for a number of centres for the purpose of bail hearings, any appeal that requires video link from abroad could only be listed at Yarswood. At present, I do not know of any other centre which is able to make facilities available. I don't think I need read 11 and 12. I'll come back to the issue of...
Do we know from the Courts and Tribunals Service what the position is?
Yeah, well, in our printed case, we've done our best to summarise what the position is. And as I said, I think I've said already, Judge Ockleton has issued some guidance on when video linking should be available. But I fall back on the position. We simply do not know of a single case which has been conducted successfully by video, well, conducted, miss out the successfully, by a video link. When we come to the material that shows the preconditions in Judge Ockleton's conditions, one can see that it's going to be relatively rare.
Yes, but it's more an administrative matter for the service to sort out where you can get a video link, where it's possible to provide it, who's going to finance it and so on, rather than Judge Ockleton.
There are two ends to a video link, if I can put it like that. There's what happens in the UK.
Yes. Oh, yes. No, I understand that. I'm just wondering, on this particular...
On that very particular point. Yes.
Does the tribunal have a power to determine who's to pay for the video link?
No, I say no. I mean, it's part of the case we put in the printed case, is that there's no provision under which the appellant, there's no provision under which any funding is made available, so that what's effectively happened in the chain of reasoning that's led to the present position is that the Secretary of State is saying, in his case to the Court of Appeal, well, you can rely on the tribunal always to identify the case which is going to require something out of the ordinary, like a video link. He or she has not made any provision to finance it. The tribunal can't finance it, certainly can't finance it in Kenya or wherever. So effectively the whole burden has come to the appellant with no indication.
Or it's open to the tribunal to say, it's our job to ensure that this is a fair procedure, and look to the Secretary of State who's administering this system to ensure that it is. I mean, it hasn't really been explored, but I'd be surprised if a lot of emphasis put by the Secretary of State on the tribunal's role in ensuring a fair procedure. But that, I'd have thought, implies that the tribunal is able to put down its foot and say, well, frankly, this isn't fair unless you, the Secretary of State, liaise with the authorities in Kenya to ensure that there are video.
Well, that's part of Bid's case. I mean, there is and I adopt that bit of it. The Secretary of State has simply taken no steps at all to ensure that video links are actually available. His case rests on the legal premise that in the vast majority of cases, it's enough to provide the unexamined.
I understand that, but I'm just pushing. If that's wrong, then the logical consequence may well be what I put to you.
Well, the logical consequence that I go for is, I mean, I think we would say that video linking may be, in a way, a bit of a red herring, because the other difficulties of running appeal from abroad are so considerable that you won't solve it just by a video link system. But if it were the case that the video link system would solve it, then the Secretary of State can't certify unless satisfied there's going to be a video link in place, and she simply can't certify on the present material. And the Secretary of State knows that because the printed case is put on the basis that the witness statements will go in unexamined. It's not put on the basis that in all cases there will be a video link, or in a very large number of cases there will be a video link.
Is there any information about what the cost would be of involving arranging video link from, say, Nairobi, and how that cost compares with the average living wage of somebody in employment in Kenya?
I don't have it at my fingertips, but I may be given an answer, and if I get an answer, I'll pass it on.
Tom's first statement, the cost. Tom's first statement, the cost.
To Mr. Giles's first witness statement, which will be in Appendix 3. MS 783. Oh, sorry. Page 783 of the paper material. MS 7649. MS 7649. And it's paragraph 8 is where there is a figure.
You've got a figure for how much it would cost.
You've got to figure for how much it will cost. That's not answering the question of whether it will be available, for which you need to deal with Judge Ockleton's observations about what is needed. I was going to go much later to that, but it may be sensible to go to that now, actually. Can I ask the court?
But when we look at this, that's the cost in Nairobi. As I understand it, the evidence is that the appellant would also have to pay for the cost in England.
Yes.
Yes.
Just on the practicalities, if I can, I was going to go at the end of the submissions on procedural fairness to Judge Ockleton's material in a case called, is it Neve? I don't know how to pronounce it, but it's in two places. The one for which I have the memory stick number is in volume 11 of the authorities bundle, paragraph tab 128. MS 3767, page 3771.
That's quite a powerful court.
Yes. And it's paragraph 16 through to 20. And tribunal says, it seems to us that at least the following points are relevant in considering whether oral evidence should be given other than by a witness present in court. First, the usual model in the common law system is for direct oral evidence to be given in the courtroom. Departures from that model are likely to reduce the quality of evidence, the ability of the parties to test it, and the ability of the judge to assess it, particularly where it has to be assessed against other oral evidence. Any application to call oral evidence by electronic link therefore needs to be justified. There's a measure of agreement across common law jurisdictions that the taking of evidence or the hearing of submissions in this way requires regulation and ought not to be regarded as routine. Civil procedure rules simply state that the court may allow a witness to give evidence through a video link or other means. But there is a lengthy practice direction That practice direction gives quite detailed guidance and is itself based on the protocol of the Federal Court of Australia. Paragraph 2 is an observation similar to that which we have made above. Video conference is, however, inevitably not as ideal as having the witness physically present in court. So on. Secondly, paragraph 18, another aspect of the giving of oral evidence live at the hearing of the appeal is subject to a measure of formality and supervision. The witness attends what is clearly a formal or semi-formal room, stands or sits in the place used by those given evidence from time to time, usually quite near the judge, and is directly subject to the procedure at the hearing. The setting of the hearing room and the judge's supervision of it, as well as the usual functions performed by the tribunal staff and the presence of the parties or their representatives, ensure that the evidence given is the evidence of the witness, unassisted, save as may be clearly apparent. Evidence is given electronically, it ought to be subject to the same or similar constraints. It should be given from formal surroundings, subject at the very least to control by appropriate officials, and it should be clear that nothing can be happening off camera or equivalent that could cast doubt on the integrity of the evidence. Thirdly, because it's a departure from the model, it's for the party seeking to reduce evidence by electronic link. To establish that for the tribunal to give evidence in this way is in the interest of justice, bearing in mind particularly the rights of other parties to challenge the evidence. It must also be for the party seeking to call evidence by electronic link to make the arrangements at the distant end and to pay any expenses. Further, no party ought to expect to be allowed adjournment simply because of the delay in making such arrangements. Fourthly, it's for the tribunal to decide whether to allow evidence to be given by electronic link and to give the appropriate directions. The tribunal needs to bear in mind the interests of all the parties and the overriding objective of the rules. Decision will not be taken lightly and no party has a right to call evidence by electronic link. If specific directions are given, they will be given in order to ensure the interests of the parties and of justice. It's therefore very unlikely that the tribunal will allow the evidence to be given by electronic link if the directions have not been complied with.
It's surprising if the British High Commission didn't have facilities for Skyping, wouldn't it?
Well, no one... We put in the evidence we put in.
Right, no, follow that. But I was just thinking if the state wants to provide an appeal system that meets what you say are fundamentals, that being a matter for argument, it can't be beyond the wit of people within that system to devise the means.
Well,
instant electronic and photographic conferencing is, after all, pretty familiar.
Well, I am not saying that it's technically impossible to provide a wide-ranging system of video links. What I am saying is that the Secretary of State at the moment certifies on the basis that that will not have happened.
Yes, sure.
There may be the occasional case where someone tries to get a video link.
Yes, we're concerned with the basis on which he's certified these cases.
Certainly,
How
for
he
whether
might
I win or
conclude.
lose this case, where that's what we're concerned with. I mean, the decision of the Court of Appeal was that the misdirection as to the effect of 94(3), subsection 3, was irrelevant because the answer was inevitably the same. And that was in the belief that in the occasional case where you needed a video link, the tribunal would somehow arrange it. But the Secretary of State's direction, expressed in his printed case, is that in the ordinary case, written statements, unexamined, will be sufficient because of the nature of the factors that need to be
I understand that, but I mean, obviously, I mean, there's two questions. One is this particular decision or these decisions valid on the basis of, say, a made? There's another one, is whether it's actually practical at all to provide a compliance system, and that's a much more difficult question.
Yes, well, at the end of the day, my submission is this court can't answer that question. The Secretary of State hasn't tried to demonstrate that such a system of wide or near universal application is practical. That isn't the task she set for herself. My submission, looking at a forensic point, that's because he can't do it. So he has to defend. She has to defend a position in which the evidence is given by unexamined written statement. Can I? Well, again, slightly out of term, but from my own previous plan, but it fits in exactly to the discussion we're having. If I can take the court to Mr. Justice McCloskey's observations in a case in the upper tribunal, a judicial review in the upper tribunal, which you will find at MS 3970. The case starts at MS 3970. It's Authorities Bundle 12. Starting at page, so tab 129. No, 139, I'm sorry, I can't read my own writing. 139, for those who are working on paper. And the passage is in paragraphs 89 and 90 at MS 4003. Now, this is what might be regarded as a very intensive fact-finding case because the background issue in the judicial review was deception. The observations go wider than that. It's paragraphs 89 and 90. 89, we will observe that the form of an in-country statutory appeal will be clearly superior to the hybrid model adopted in these proceedings for the full exploration and consideration of all the evidence, and in particular the finding of whether the applicant was engaged in deception as alleged. This sounds on our conclusion concerning conspicuous unfairness. The suitability of an out-of-country appeal in this sphere of litigation, indeed in others, has not yet, to our knowledge, been fully tested at either tier, and thus remains a moot question. In this context, we draw attention to what this tribunal stated in SM and Kiarie. And the quote is, "We are conscious that some future appeals may be of the out-of-country species. It is our understanding that neither the first-tier tribunal nor this tribunal has experience of an out-of-country appeal of this kind, whether through the video link or Skype or otherwise." Supposing there, no experience of an out-of-country appeal of this kind, whether through Skype, video link or otherwise. The question of mechanisms of this kind are satisfactory, and in particular the legal question of whether they provide an appellant with a fair hearing will depend upon the particular context and circumstances of the individual case. This predictably is an issue which may require future judicial determination. The Upper Tribunal now has experience of a broad range of ETS or TOEIC hearings, error of law hearings, remaking hearings, conventional judicial review hearings in the hybrid model adopted in this case. In SM and Kiarie, the tribunal observed, furthermore, the hearing of these appeals has demonstrated beyond peradventure that judicial review is an entirely unsatisfactory litigation for the vehicle for the determination of disputes of this kind. Words of this kind refer to cases such as SM and Kiarie and MA, in which the facts relating to the relevant events are of critical importance, and in consequence the evidence requires penetrating examination. Experience has demonstrated in such cases detailed scrutiny of the demeanour and general presentation of the parties and witnesses is a highly important factor. So too is close quarters assessment of how the proceedings are being conducted. For example, unscheduled requests for the production of further documents, the response thereto, the conduct of all present in the courtroom, the taking of further instructions in the heat of battle, and related matters. These examples could be multiplied. I have found the mechanism of evidence by video link to be quite unsatisfactory in other contexts, both civil and criminal. It's not clear whether the aforementioned essential judicial exercises could be conducted satisfactorily in an out-of-country appeal. Furthermore, there would be loss of judicial control on supervision of events in the distant, remote location, with associated potential for misuse of the judicial process. The conventional video-linked bail hearing, in which the subject is virtually present, but making little or no active contribution, is to be contrasted. And then 91 is dealing with the fact that this was, in fact, a judicial review, not a primary case in which primary facts failed to be found. So all of this started with my submission that the appeal that my client would face was a very different animal from the classic entry clearance appeal, in which the issues would fundamentally relate to material in the country of origin, and which will be the sort of issues that arise on the points-based system or the prescriptive evidential rules about financial requirements and matters of that sort. So, can I then just go to the last source of material about what's at issue in the appeals? The court will be more than familiar with this, but it's, if I can use the recent case of Hesham Ali as the agenda, which court will find at volume 8 of the authorities manual, MS 2800. It starts at 2800. If I can pick up the bits that we need. First of all, just to run through the statutory framework, I know the court's plainly grappled with this in other cases. But paragraphs 10 through to 12 deal with section 32 of the 2007 Act. And we end up with the position that there's an exception to the rule for automatic deportation contained in 32(2), which is where removal of the foreign criminal in pursuance of the deportation will breach a person's convention rights. And then subsection 7 says the application of an exception, A, does not prevent the making of a deportation, B, results in it being assumed that neither that the deportation of the person concerned is conducive to the public good, nor that it should be conducive to the public good, but 32(4) applies despite the application of exception 1 and 4.
That's clear as mud, isn't it?
Clear as mud, and that's what Lord Reid says in the second part of paragraph 12, which I won't read, but it's a bit puzzling that you're liable to be deported even though deportation is barred, and it gives a potential explanation. But that's where we were. That's where we are here. It is worth bearing in mind the rules which are applicable in my client's case and which are set out by Lord Reid in paragraph 23, page 2810. And having described various policy statements, Lord Reid says these policies were given effect to by the new rules. And then 398 where a person claims that their deportation will be contrary to the UK's obligations under Article 8, and then we need to go into B, the deportation of the person from the UK is conducive to the public good because they've been convicted of an offence for which they've been sentenced to a period of imprisonment of less than 4 years, but at least 12 months. And that's my client's case. He's under 4 but over 12 months. The Secretary of State in assessing that claim will consider whether paragraph 399 or 399 large A applies, and if it does not, it will only be in exceptional circumstances that the public interest in deportation will be outweighed by any other factors. 399A is our case, or relevant to our case. Yeah, but I've given them the current date. Need to be careful about whether I've got the exact current version of section 32.
Is it 399 large A B?
Yes.
Applies to you?
Well, we say it does.
Aged under 25, has spent at least half his life living continuously. Yeah.
Oh, I see. It doesn't make any difference to the half year. No. I may need to be completely accurate about the slightly later version that I'm not going to confuse myself by doing that now. I don't think it makes any difference to the point I'm making. On the face of it, we are in 399 large A and B, were aged under 25, spent at least half his life living continuous in the UK immediately preceding the date of the immigration decision, and has no ties, including social, cultural, or family, with the country to which he would have to go if required to leave the UK.
I thought he had a grandmother.
Yes, I was going to go on to say there will be a live issue. What the Secretary of State says in the decision letter in Mr. Kiarie's case is that he asserts he has no connection with Kenya, but in an earlier case there was a reference to the grandmother. Now, there's plainly going to be a factual issue about whether or not that satisfies the requirement no ties.
No family ties.
No family ties.
I see.
I'm only going to this to demonstrate that this is, I mean, others would probably call it a near miss. I mean, however you look at it, he's here for, he's under 25, been here more than half his life, and has an arguable case he has no ties.
So B is not in dispute, C is a matter of argument. So not B, but B down to
exactly
the comment about ties.
Just looking at the written material, one can't get a conclusive answer to the full weight of B.
And if he gets within 399 big A, then he's not within the exceptional circumstances test under...
Yes, he's got a straightforward... Exactly. Yeah.
So it's an important point.
Yes. So that's factual issue one that needs investigation. My client is the immediate and obvious witness to give evidence about that. And similarly, I mean, just to go back to my perspective, his relatives will give evidence at the putative appeal we're thinking about. They will be cross-examined by the presenting officer about whether he has family ties. And on the Secretary of State's model, he will not be there, able to respond to the developments in the giving of the evidence. And we say that's just a fundamental unfairness. We then go on to look at the other ingredients. Paragraph 26.
I mean, presumably also whether he has family ties in Kenya is very relevant to whether it's proportionate to expel him on a temporary basis.
On a temporary basis, yes. Yes. And then paragraph 26 in Lord Reed's judgment sets out the Bultiff and Maslow criteria. I'm not going to read that, of course, more than familiar with them. But there will be a range of issues: risk, integration, family ties, and so on, all of which require investigation. and up until the certification regime would have been investigated at an oral hearing in front of the tribunal. And then the final task of the court, the tribunal rather, is set out in paragraph 32 of Lord Reed's judgment, where, having discussed jeunesse, he comes to the practical conclusion that the difference between positive and negative obligations is unlikely to be of substantial importance. And goes on to say that what matters is whether or not a fair balance is being struck. And just to finish this off, the Secretary of State's printed case refers to Lord Thomas's checklist approach, which the court will see balance sheet approach, or rather, paragraph 83, memory stick 2828. The simple point I make here is that what Lord Thomas is advocating is that, first of all, the tribunal find the facts. Just under G, judges should, after making their factual determinations, set out in clear and succinct terms their reason at the conclusion arrived at through balancing the necessary considerations. And get the same thing out of 83. After the judge has found the facts, the judge would set out each of the pros and cons in what has been described as a balance sheet, and then set out reasoned conclusions. And he refers to an adoption case and an extradition case in paragraph 84. Now, my point is simply that that's, of course, totally compatible with the routine model of an oral hearing at which the appellant and his witnesses give evidence, are cross-examined. Judge then finds facts related to all of the Bultieff and Maslov criteria, and draws up his checklist if he's following the advice. So, it's in a hearing of that nature that we say the regime, the certification regime doesn't work. And the principal authority on what is required for Article 8 procedural fairness, on which I rely, partly because it summarises the Strasbourg jurisprudence, Strasbourg case law, is a case called Gudanovician, which is about exceptional funding in the legal aid regime. The court will find that in Authorities Bundle 10, tab 111, memory stick number 3384. It's got a very long head note, which I won't read. And at paragraph 24,
could you just give me the page number for that again, please? Paragraph 24. The
paragraph 24
MS number.
is 3397, sorry.
3397, thank you.
MS 3397. Lord Dyson identifies the issues. Ground 1 concerns the proper interpretation of 10.3. No dispute about that anymore. The issue in ground 2 is whether the guidance, that was the guidance given to legal aid caseworkers, is compatible with Article 6 of the Convention and Article 47 of the Charter. The issue in ground 3 is whether the guidance is compatible with Article 8 of the Convention in immigration cases. The court considered the case law on Article 6 and Article 47 of the Charter, which were aligned, and then went on to consider Article 8, procedural fairness in the context of immigration cases, and came to the view that the test would be identical in the present context. And then we'll see that the case law on on Article 6 starts with setting out a central passage from Kiarie, paragraph 24 of Kiarie, memory stick number 3400, and it's the first few sentences are sufficient.
Paragraph 24, yeah.
It's 24 of Kiarie, paragraph 35 of the judgment, good and novitium. The Convention is intended to guarantee not rights that are theoretical or illusory, but rights that are practical and effective. This is particularly so of the right of access to the courts, in view of the prominent place held in a democratic society by the right to a fair trial. It must therefore be ascertained whether Mrs. Kiarie's appearance before the High Court without the assistance of a lawyer would be effective, in the sense of whether she will be able to present her case properly and satisfactorily. Contradictory views on this question were expressed by the government and the Commission during oral hearings. It seems certain to the court that the applicant would be at a disadvantage if her husband were represented by a lawyer and she was not. And then, quite apart from this eventuality, it's not realistic in the court's opinion to suppose that in litigation of this nature, the applicant could effectively conduct her own case, despite the assistance which, as was stressed by the government, the judge affords the parties acting in person. And then there's a reference to the technical and procedurally complicated nature of judicial separation procedures in Ireland, in the Republic. But we end up with the proposition at in the second sentence, third sentence. The issue is whether Mrs. Kiarie's appearance before the High Court without assistance of a lawyer would be effective, in the sense of whether she would be able to present her case properly and satisfactorily. Then there's a reference in paragraph 36 to X against the United Kingdom, and a quotation from which was a commission hearing concerning an industrial tribunal. And the approach that the Commission took to the provision of legal aid in the industrial tribunal was, second sentence, only in exceptional circumstances, namely where the withholding of legal aid will make the assertion of a civil claim practically impossible, where it would lead to an obvious unfairness of the proceedings, can such a right be invoked by virtue of 6.1. The test became obvious unfairness, as we'll see in a moment. So does legal aid lead to an obvious absence of legal aid lead to an obvious unfairness? And then P, C, and S, principles summarised with a slightly different emphasis. Paragraphs 89 to 90, the court said that failure to provide an applicant with the assistance of a lawyer may breach Article 6.1, where such assistance is indispensable for effective access to the court by reason of the complexity of the procedure or the type of case. Thus, though the pursuit of proceedings as a litigant in person may on occasion not be an easy matter, the limited public funds available for civil actions renders the procedure of selection necessary. And the issue at the end of that quote is whether or not the absence of legal aid impinges on the essence of the right of access. And secondly, paragraph 91, the key principle governing the application of Article 6 is fairness. In cases where an applicant appears in court notwithstanding the lack of assistance of a lawyer and manages to conduct his or her case in the teeth of all the difficulties, the question may nonetheless arise as to whether the procedure was fair. There is the importance of ensuring that the appearance of the fair administration of justice and a party in civil proceedings must be able to participate effectively by being able to put forward the matters in support of his or her claims. Now, if we can just stop there. Oh, sorry, no, I read the last sentence is important. Here, as in other aspects of Article 6, the seriousness of what is at stake for the applicant will be of relevance to assessing the adequacy and fairness of the measures.
Well, that was a case about removal of a baby, basically, from
Yes.
family, wasn't it?
Yes, it was. And if leadership will recall, I mean, it was a case where I think it was the mother ended up unrepresented in complicated family proceedings. And the judge bent over backwards to try to make the thing work. And that provoked from the Strasbourg court the comment, in cases where an applicant appears in court notwithstanding lack of assistance of a lawyer manages to conduct his or her case in the face of all the difficulties, the question may nonetheless arise whether this procedure was fair. Now, that thought, in my submission, has a resonance in the present facts. The Secretary of State, when she certifies, is looking forward to the conduct of the appeal. The Secretary of State expresses the hope that the tribunal will solve any difficulties by reference to video conferencing or potential application for a witness summons to get the appellant back in and so on. Now, those sort of ad hoc measures, which in my submission can't be predicted from the beginning, have all the appearance of the tribunal struggling on in the face of all the difficulties, making ad hoc judgments about what on earth it does with a situation which hasn't been properly assessed by the Secretary of State at the moment of certification. No doubt the tribunal will do its best to sort it out, but that isn't an answer to the PC&S perspective. Then there's a reference to the Steele and Morris, McDonald's case. And then paragraph 42 records my submission that the test in X was an aberration. Which the court resolved by saying that by saying just above letter F on memory stick 3403, the case has set out the kind of factors which were relevant for the resolution of this issue. The phrase obvious unfairness as a summary is wide enough to capture the guidance given in the jurisprudence. So we end up with obvious unfairness being the hallmark of the application of the Article 6 principles. And then in paragraph 46, court says, general principles established by the European Court of Human Rights are now clear. Inevitably, they are derived from cases in which the question was whether there was a breach of Article 6.1 in proceedings which had already taken place. We accept the current following summary of the relevant case law given by Mr. Drabble. 1, the Convention guarantees rights that are practical, effective, not theoretical and illusory, in relation to the right of access to the courts. The question is whether the appellant's appearance before the court or tribunal in question without the assistance of the lawyer was effective, and the question of whether he or she was able to present the case properly and satisfactorily. 3, it's relevant whether the proceedings taken as a whole were fair. 4, the importance of the appearance of fairness is also relevant, simply because the applicant can struggle through in the teeth of all the difficulties. It does not necessarily mean the procedure was fair. And 5, equality of arms must be guaranteed to the extent that each side is afforded a reasonable opportunity to present his or her case under conditions that do not place them at a substantial disadvantage vis-à-vis their opponent, Steele and Morris. And we end up with the last comment on Article 6 in paragraph 56, MS 3407. Therefore be seen that the critical question is whether an unrepresented litigant is able to present his case effectively and without obvious unfairness. The answer to this question requires a consideration of all the circumstances of the case. Or can read this. I don't think I need. That's the ultimate background test. And then we go on over the page 3409 to ground 3. Is the guidance compatible with Article 8 of the Convention in immigration cases? And paragraphs 60 and 61 record Mr. Chamberlain's submission. Mr. Chamberlain appeared for the Lord Chancellor, Director of Legal Aid Casework. And the submissions in 60 and 61 are essentially those made in the Secretary of State's printed case in the present case. Mr. Chamberlain submits as follows. There is no Strasbourg authority which has decided that Article 8 alone requires the provision of civil legal aid in an immigration case. There's a good reason for this. The decision of the Grand Chamber in Moyer makes it clear that decisions relating to entry, stay and deportation do not involve the determination of civil rights, therefore outside the scope of 6.1. This is so notwithstanding that the decisions in question may incidentally have major repercussions on the applicant's private and family life or his prospects of employment. Paragraph 38. The implications of the decision by the European Court of Human Rights to exclude immigration decisions from the scope of Article 1 were considered by the House of Lords in MT Algeria. Case concerned an appeal by 3 individuals who were subject to deportation proceedings on national security grounds, all of whom alleged that their deportation would be contrary to their rights under Article 3. They challenged the fact that the Special Immigrations Commission, SIAC, had used closed material in reaching its conclusions. They accepted that Article 6 did not apply, since the deportation orders did not involve the determination of civil rights. They argued, however, that since their substantive rights under Article 3 were at stake, they were entitled to have the issue of the interference with those substantive rights determined in accordance with a procedure that satisfied Article 6. This argument was rejected. In his skeleton argument, Mr. Chamberlain submits that if in reliance on Article 3 did not suffice to confer on the appellants on in the MT case procedural guarantees akin to those which would have arisen under Article 6, it is difficult to envisage circumstances in which reliance on Article 8 could achieve a similar result. And then there's in paragraph 62 sets out some softening of Mr. Chamberlain's submissions. And then then there's a heading discussion immediately above paragraph 64. And court starts by setting out an important passage from W in the United Kingdom, which is another family case. And the passage is, in the court's view, what therefore has to be determined is whether, having regard to the particular circumstances of the case, and notably the serious nature of the decisions to be taken, the parents have been involved in the decision-making process, seen as a whole, to a degree sufficient to provide them with the requisite protection of their interests. If they have not, there will have been a failure to respect their family life, and the interference resulting from the decision will not be capable of being regarded as necessary within the meaning of Article 8. So that as the next sentence says, is a test repeated frequently in the Strasbourg case law. The basic focus is whether the parties have been involved in the decision-making process to a degree sufficient to provide them with the requisite protection of their interests. And 66, Lord Dyson says, this statement of the law has often been repeated by the European Court of Human Rights. Effective involvement in the decision-making process may require the grant of legal aid. Already considered some of the relevant authorities in our consideration of the Article 6.1 issue. And then there's a reference but first of all to Kiarie and then to P, C and S, where Lord Dyson says the court, having decided that there was a breach of Article 6.1, the court said, paragraphs 136 to 137, court does not propose to attempt to untangle these opposed considerations which raise difficult and sensitive issue concerning S's welfare. It seems rather that the complexity of the case and the fine balance which had been struck between the interests of S and her parents required that particular importance be attached to the procedural obligations inherent in Article 8 of the Convention. It is crucial for the parents in this case to be able to put forward their case as favourably as possible, emphasising, for example, whatever factors militated in favour of a further assessment of possible rehabilitation and for their viewpoints on the possible alternatives to adoption and continuation of contact even of adoption to be put forward at the appropriate time. The lack of legal representation of P during the care proceedings and of P and C during the freeing for adoption proceedings, together with the lack of any real lapse of time between the two procedures, has been found to have deprived the applicants of a fair and effective hearing in court. Having regard to the seriousness of what was at stake, the court finds it prevented them from being involved in the decision-making process, seen as a whole, to a degree sufficient to provide them with the requisite degree of protection of their interests under Article 8. Emotionally involved in the cases there were, the applicant parents were placed at a serious disadvantage by these elements, and it cannot be excluded this might have had an effect on the decisions reached and the eventual outcome for the family as a whole. In the result, for 67, the court found there had been a breach. As Ms. Kaufman says, although the European Court of Human Rights adopted the form of sufficient involvement in the decision-making process rather than effective access, the effect was the same in that case. So there we have the Court of Appeal recognising that the two tests, absent some features of Article 6 to which I'll come, are the same. And that is what the court says in paragraph 69 and 70. Four lines below letter G, does not follow the procedural obligations of Article 8 do not apply to immigration decisions. Mr. Chamberlain is right to concede that Article 8 can apply in immigration cases. Article 8 is frequently engaged in immigration cases. The procedural protections inherent in Article 8 are necessary in order to ensure that Article 8 rights are practical and effective. The necessity for this is at least as important in immigration as in any other cases. Indeed, the WV United Kingdom test being applied by the European Court of Human Rights in immigration cases, see Sealis and Sinigo Longue v. France. True that the test for Article 8, as it is stated in Strasbourg jurisprudence, brackets, whether those affected have been involved in the decision-making process viewed as a whole to a degree sufficient to provide them with the requisite protection, their interest differs from the test for Article 6.1, whether there's been effective access to the court. The Article 8 test is broader than the 6.1 test, but in practice we doubt whether there is any real difference between the two formulations in the context with which we are concerned. Nothing in the Strasbourg jurisprudence to which our attention has been drawn suggests the European Court of Human Rights considers that there's any such difference. In practice, the court's analysis of the facts in the case law does not seem to differ as between Article 6.1 and Article 8. This is not surprising. It goes on just 2 sentences later, the focus of the procedural aspect of Article 8 is to ensure the effective protection of an individual's Article 8 rights. And then in paragraph 71 summarises the upshot of all of that. I'm asked to read by Mr. Fordham to read the last sentence. Yes, the last sentence of 70 certainly will read it. Summarise, in determining what constitutes effective access to the tribunal, Article 6.1, and constitutes sufficient involvement in the decision-making process for Article 8 for present purposes, the standards are in practice the same.
What did he mean by present purposes? Did he mean immigration purposes, or did he mean legal aid purposes?
he means immigration purposes. When we see the rest of the case law, there are some aspects of 6.1 which are hinted at, 6, which are hinted at in Mr. Chamberlain's submissions by the reference to MT Algeria, where if you approach the closed procedure in a national security case through 6.1, you will find a hard-edged obligation to provide details of the charge contained within Article 6. And it is quite true that when you go to MT and a similar line of cases, that is not read across into Article 8, because Article 8 is a qualified right. So I have read, and I submit, that what Lord Dyson is saying, that unless that sort of consideration is in play, in other words, you're dealing with an immigration case of substance, of importance to the individual, no particular reason why procedural fairness shouldn't be guaranteed, and the contents of the two obligations are the same. So what he's doing, I mean, this is material for the way in which the Secretary of State puts his case in the present case, is rejecting Mr. Chamberlain's submissions, which, as I say, are very close to those which are made in the present proceedings.
I think the Advocate General says that the most focused analysis of the removal of somebody before an appeal in an immigration context in Strasbourg is this case of De Souza Ribeiro, which you might be coming on to.
I am going to come on to.
Good.
Yes. Yep. So we end up at the end of Gudanovicia and with the proposition which I stay with, that the Court of Appeal has rejected MT-based submissions of Mr. Chamberlain, and come to the conclusion that the contents of the two limbs or the contents of the two articles in this context are the same, and will indeed come to the cases relied on by the Secretary of State in just a moment. Keep an eye on the time. So that's Gudanovicia. We then go to back to our printed case, which asks the court to go back to a memory stick 6616 in the core volume.
Well, this is merely saying what you've already said.
That bit is really saying what I've already said, and I won't say it again.
Good, because you haven't got unlimited time.
We're saying what we've already said up to paragraph 118,
Yes.
which is at 6619. And we end up in 118. Saying the principles to be derived from the Strasbourg cases do not, however, shed much light on the way in which the standard of fairness should operate as between different classes and types of proceedings, save, for instance, in the references to the series of what is at stake, C, P, C, and S. For that, we must turn to a separate strand of authority, and the strand of authority concerns the sliding scale. I'll take this relatively rapidly, but the concept is that certainly it's well established for Article 6 proceedings that the standard of protection is enhanced if what is at stake is extremely serious for the individual, which is obviously the present case, because deportation on the face of it is an extremely serious matter, particularly to a country with which you have little or no ties. And the
It's going to vary, is it not? we can't assume that all deportation of foreign national criminals will have the same impact. I mean, obviously, it is a serious thing, but the level of seriousness will vary, won't it?
I mean, yes.
You could say that for somebody who's been in this country since the age of 3, it's obviously serious.
My response on behalf of Mr. Kiarie is that
Yeah.
we're at a fairly extreme end of seriousness, given that he's been here since the age of 3. It's not necessary for me to say this, but I would certainly submit that in almost any permanent deportation case, of a settled national anyway, consequences are serious and will engage a high level of procedural protection. Quite, that is of contrast with the entry clearance cases. I mean, there will be entry clearance cases in which the level of seriousness is very much less. There will be quite serious entry clearance cases in which it's very high, but there will be ones which is very much less. Visitor's visa or student visa or whatever. But that's not deport. In any event, if I can just kind of do a whistle-stop through the authorities that we refer to, it is possibly worth looking at the Comte, although it's a very familiar authority. It's Authorities Bundle 12.
But is the principle controversial at all? We seem to have an awful lot of authorities with respect in your case to demonstrate things which are pretty straightforward.
Well, it's not. I don't imagine it's controversial as far as Article 6 is concerned, is the answer to your Lordship's question. It's certainly controversial that it applies.
Okay, well, anyway, what are we looking at?
Well, I don't want to spend a lot of time on matters which are... We're going to look at Le Comte. Hang on a minute. Let me just see whether there's...
I mean, I've read all what you say about all this, and so
Yes.
I've taken into account. It doesn't strike me as being particularly enlightening.
Well, is it accepted that under Article 6 there is a sliding scale of procedural protection depending upon the seriousness of what is at stake for the individual litigant? Is that accepted? It appears to be accepted. What isn't accepted is that Article 8 requires the same. That's...
Yes.
Which is what you just told us, in fact.
It is what I just told you.
We may be trying to be helpful.
Well, yeah, I understand. Well, can I park that part of the printed case then? See where we get to. That's probably the battleground may be the Article 8 cases, which is the next port of call. Can I just make this observation? We do say in the printed case, we make the submission on memory stick page 6587. In answer to one of the issues formulated in the Statement of Facts and Issues, the foot of the page, having referred to the sliding scale, gravity of the deportation for a long-term settled migrant, require the appellant be afforded the highest standards of fairness, most cases giving rise to an arguable case on an appeal, an out-of-country appeal will not be sufficient. D, this proposition can be tested by contemplating a situation where there is an oral hearing. Live evidence, for example, from members of the appellant's family is heard. Respondent examines that the appellant is not present or in any other way able to give instructions or react to developments during the course of the hearing. The appellant submits this situation is obviously incompatible with the required level of procedural protection, given the difficulties surrounding video link conferencing as well as the issuing of a witness summons to secure the appellant's attendance. The acceptability of this simple example is an important part of the Secretary of State's argument. And that last bit is going over exchanges that we had relatively early in the hearing. The first bit I've already hinted at, but it's the crunch point when it comes to the combination of seriousness and procedural protection. We do say that a situation which would be routine, that where there's an oral hearing and the appellant is absent, is not compatible with the requisite standards of procedural fairness. If I can then go on to the case advanced by my learned friend in relation to why Article 8 produces a different answer. Paragraph 62 of his printed case memory stick 6767 has, having referred to my example that I've just read to the court, paragraph 62, that analysis bears little resemblance to the approach reflected in the Strasbourg case law, from which the following propositions emerge. First, Article 6 does not apply to cases concerning the expulsion, and then Moya, if that's how you pronounce it, against France is cited. That is at Bundle Authorities Volume 13, page 182, say 152.
That's accepted, isn't it?
Yes. But some of this is negative. It's simply saying that all these propositions don't take you to a position where Strasbourg has sanctioned anything resembling the absence of an appellant from an otherwise live oral hearing. That's the proposition. So Moya, which just for a note is at MS 4423, my submission on it is it simply doesn't carry this particular argument any further forward. It tells you we're not in Article 6, we are in Article 8, and it doesn't tell you much more than that. The next proposition it is worth going to is that IR and GT against the United Kingdom cited as authority for the proposition that procedural rights inherent in Article 8 will vary in accordance with the context and may not be as demanding as the guarantees in Article 6. Put like that, that's accurate, but unilluminating in relation to the present issue. If we go to memory stick page, it's 16178, and the authority starts at memory stick 5209. Which bundle?
116.
Sorry, 16. And there's a heading on MS 5221, immediately above paragraph 57. Heading is General Principles Concerning Procedural Safeguards under Article 8 in National Security Immigration Cases. So the clue is in the heading. It's dealing with the impact of the fact you're dealing with national security in a qualified right such as Article 8. And 57 says, in a series of Bulgarian cases, the courts developed the idea of the need for procedural safeguards as an integral feature of the lawfulness of deportation and exclusion decisions under Article 8 of the Convention. Clear from this case law that even where national security is at stake, the concepts of lawfulness and the rule of law require measures affecting fundamental human rights to be subject to, and then quote, some form of adversarial proceedings before an independent body competent to review the reasons for the decision and relevant evidence, if need be, with appropriate procedural limitations on the use of classified information. Context of such proceedings, the executive's assertion that national security is at stake must be open to challenge, while the executive's assessment of what poses a threat to national security will generally be of significant weight. The independent authority must be able to react in cases where the assessment has no reasonable basis in the facts or reveals an interpretation of national security that is unlawful or contrary to common sense and arbitrary. And then 58, dealing with the actual subject matter of the closed procedure dispute, the use of confidential material in the proceedings may be unavoidable where national security is at stake. It may sometimes be necessary to classify some or all of the proceedings used in proceedings touching upon matters of national security and even parts of decisions rendered in them. However, the complete concealment from the public of the entirety of a judicial decision cannot be regarded as warranty. The publicity of judicial proceedings aims to ensure scrutiny of the judiciary by the public and constitutes a safeguard against arbitrariness. And then the core of the complaint by the applicant's first sentence of paragraph 59, the core of the applicant's case is that Article 8 requires more specific information to be provided as to the nature of the allegations against them and the purported threat to national security. In order to succeed, the applicants must establish the procedural guarantees under Article 8 required such information to be disclosed in the circumstances of their cases. So the obligation was full disclosure. And then we go on to paragraph 62. This is the paragraph that's cited in the third of the Secretary of State's propositions in, actually coincidentally, paragraph 62 of his case. The procedural aspect of Article 8 should be interpreted consistently with the right to an effective remedy under Article 13. And paragraph 62 of the Strasbourg judgment says further, given the overlap between the procedural safeguards under Article 8 and the right to an effective remedy under Article 13, the former should be interpreted in a manner consistently with the latter. It's noteworthy that as far as Article 13 is concerned, the court has accepted the context in which a violation occurs might entail inherent limitations on the conceivable remedy. In such circumstances, the requirement in Article 13 of an effective remedy is read as meaning a remedy that is as effective as it can be, having regard to the restricted scope for recourse inherent in the particular context. So pausing there, what that is saying is that in an Article 8 context concerning national security, there's an inherent limitation on procedural guarantees that would otherwise be present because of the nature of the subject matter. Yep. The last sentence of 61, my learned friend says, it follows that the procedural guarantees inherent in Article 8 will vary according to on the context of the case in question, and in some circumstances may not be as demanding as those which apply under Articles 5 and 6.
That's in a discussion of Article 6.3a, which explicitly requires a person charged with a criminal offence to be given details of the nature and case of the accusation against him.
Exactly.
The court is contrasting that with secret surveillance and so on, where that sort of information may not be able to be given.
That's exactly my case.
That's what
Article 6 works by guaranteeing a general right to a fair trial in 6.1, and then a series of specific guarantees which you can't get out of if you're the convention state.
So you say that I imagine the last sentence of 61 has to be read in the context of what goes before, which is Article 6.3a.
The whole case is about whether the closed procedure is acceptable under Article 8 in circumstances where it plainly wouldn't be acceptable in an ordinary civil trial, civil or criminal trial to which Article 6 applied. That's what the case is about. And accordingly, the whole structure of my learned friend's case, third proposition in his paragraph 62, is built on far too wide a reading of what is happening in the closed procedure case.
But it's not even a civil trial. I mean, what it's talking about in 638 is a criminal charge.
Yes. You're quite right.
Yes. Which is a further restriction.
Yes.
Yes.
Yes. Going back to Lord Dyson in Gudanovichian, the present context in my submission, what he had in mind was that the would-be cases, because these cases were cited to him, where there were specific guarantees in Article 6, this is Article 6.3, as we've just been discussing, which don't read across into Article 8 because of the different subject matter, but that's not our case. I'm not going to spend any more time on that. You get exactly the same. Go back to our printed case 6654. 4 volume 6654.
You say 6654.
Yes, I did, and that's in our supplementary.
It's your supplementary
It's in our
case.
supplementary case, which is where I meant to go, but I didn't manage to say that. And there we're dealing with the limbs of we learn a friend's case as expressed in paragraph 62. Paragraph 9 makes the point we've just been exploring. One probably doesn't need any further illumination of what IR Sri Lanka was about, but it's crystal clear from Lord Justice Morris Kay's judgment, giving you the reference to that in the domestic proceedings. Paragraph 10 says that proposition reflects a line of Strasbourg cases to the effect that protections must be as effective as can be. Read what we say in paragraph 10. And then we get on to the D'Souza Ribeiro and Khalifa cases, which I do need to deal with. And you'll find D'Souza Ribeiro at volume 16 for MS 5226. Yes, volume 16, which I've got. Tab 179 if we're working off the paper ones. The background in D'Souza Ribeiro.
This is a Grand Chamber case, isn't it?
Yes. Background can be seen from the head note. Let's take this sufficiently slowly. In 1995, the applicant travelled on a tourist visa from Brazil to Cayenne in French Guiana to join his parents, who had permanent residence cards, and his 4 siblings, one of whom had French nationality and the other 3 were entitled to apply for it as they were born in the French territory. The applicant attended school there until he was 16, did not hold proper residence papers and had to leave school, unable to apply for residence papers until he reached 16. In May 2005, the applicant was arrested for a drug offence, placed under court supervision and was not allowed to leave French Guiana. In October 2006, the applicant was sentenced to a suspended prison sentence, 2 years probation, which included reporting to the authorities and undergoing training. The applicant commenced a vocational training course from October 2006 to March 2007. The dates matter, 25th of January, the applicant was arrested at a road check, unable to show that his presence in French Guiana was legal, and administrative removal and detention orders were issued against him. The applicant lodged an application for judicial review of the removal order, requested that he be issued with a residence permit. The applicant simultaneously lodged an application for the court to suspend enforcement of the removal order on the basis that it was unlawful. On the 26th of January, that's the next day, the applicant was removed to Brazil. Cayenne Administrative Court held that the application for the suspension of his removal was devoid of purpose, as he had already been deported. Applicant's application for legal aid against the ruling was rejected. In February 2007, the applicant lodged an urgent application for protection of fundamental freedom with the Cayenne Administrative Court and requested his return to defend himself against the alleged violation to be reunited. Application rejected on the basis that the measure sought was permanent, and the urgent applications judge could only order interim measures, and then he is returned finally in September 2009 after further judicial review proceedings. Now, the statement of principle which my learned friend founds is at paragraph 79 through to 83, memory stick 5247. Paragraph 79 says the effectiveness of a remedy within the meaning of Article 13 does not depend on the certainty of a favourable outcome for the applicant, nor does the authority referred to in that provision necessarily have to be a judicial authority. Nevertheless, its powers and procedural guarantees which affords are relevant in determining whether the remedy before it is effective. When the authority concerned is not a judicial authority, the court makes a point of verifying its independence and the procedural guarantees it offers applicants. Also, even if a single remedy does not by itself entirely satisfy the requirements of Article 13, the aggregate of remedies provided for under domestic law may do so. Now, pausing there, my learned friend builds an argument on that to say that one looks, in the present case, not just at the certification, but at the ability to judicially review the aggregate of remedies. Now, that proposition may be true in an Article 13 context, but as I've already submitted, must be irrelevant for the purpose of the lawfulness of the certificate in the context in which we're envisaging it. It may well be that if you can judicially review a certificate before you're removed, that demonstrates the UK has an effective remedy. But it doesn't demonstrate the certificate is lawful, because your judicial review has demonstrated it's unlawful. The answer to the point is as simple as that. That's paragraph 79. Paragraph 80, in order to be effective, the remedy required by Article 13 must be available in practice as in law. In particular, in the sense its exercise must not be unjustifiably hindered by the acts or omissions of the authorities of the respondent state. In addition, particular attention to be paid to the speediness of the remedial action itself, since it's not inconceivable that the adequate nature of the remedy could be undermined by its excessive duration. Then 82, where a complaint concerns allegations that the person's expulsion would expose him to a real risk of suffering treatment contrary to Article 3, in view of the importance the court attaches to that provision, and given the irreversible nature of the harm that might occur if the risk of torture or ill treatment alleged materialised, the effectiveness of a remedy for the purpose of Article 13 requires imperatively that the complaint be subject to close scrutiny by a national authority, independent and rigorous scrutiny of a claim that there exists substantial grounds for fearing a risk of treatment, a real risk of treatment contrary to Article 3. In such a case, effectiveness also requires that the person concerned should have access to a remedy with automatic suspensive effect. The same principles apply when expulsion exposes the applicant to a real risk of a violation of his right to life safeguarded by Article 2. Lastly, the requirement that a remedy should have automatic suspensive effect has been confirmed for complaints under Article 4 of Protocol number 4. By contrast, where expulsions are challenged on the basis of alleged interference with private and family life, it is not imperative, in order for a remedy to be effective, that it should have automatic suspensive effect. Nevertheless, in immigration matters, where there is an arguable claim that expulsion threatens to interfere with the alien's right to respect for his private and family life, Article 13, in conjunction with Article 8 of the Convention, requires that the states must make available to the individual concerned the effective possibility of challenging the deportation or refusal of residence order and having the relevant issues examined with sufficient procedural safeguards and or thoroughness by an appropriate domestic authority offering adequate guarantees of independence and impartiality. Now, it is obviously correct that 82 and 83 draw a contrast between Articles 2 and 3 on the one hand and Article 8 on the other. Requirement for automatic suspensive effect in the first category, but not in the latter. But what paragraph 83 is not dealing with is a situation in which removal renders the procedural safeguard unfair. It's a requirement of Article 13, according to the last sentence of paragraph 83, that the states must make available to the individual concerned the effective possibility of challenging the deportation order and having the relevant issues examined with sufficient procedural safeguards. Secretary of State says that requirement is met because of the appeal. If true it is that there's no ban on, there's no requirement for automatic, an automatic suspensive effect, but if the effective removal is to mean that the relevant issues cannot be examined with sufficient procedural safeguards, because the examination takes place in an oral hearing, at which one party is present and the other is not, then this authority provides no illumination at all. It simply isn't addressed to a situation where the removal renders the safeguard unfair. I'm going to say nugatory, that may be putting it too strongly, but unfair. Simply isn't the issue with which the Strasbourg Court was grappling. And indeed, this court reads on at some point in the passage called Application of these Principles to the Present Case, find that there was actually a finding that there was a breach of Article 13 on the facts of the present case. I don't think that matters very much, but there was. So that's our answer, that's our analysis of de Souza Ribeiro. Go back to our further responses to the other authorities cited by my learned friend in his printed case. Khalifa is at 16182. It's in the same volume, actually. And it's a fairly long report. And the report starts at MS 5346. The most relevant passage is at 278 through to 281. The case of collective removal from Italy.
Could you give me a MS number, please?
Sorry, Lord Lady, yes, 5436 for the relevant passage. And, or possibly starting at 277, court takes the view that where, as in the present case, an applicant does not allege that he or she faces violations of Article 2 or 3 in the destination country, removal from the territory of the respondent state will not expose him or her to harm of a potentially irreversible nature. And then 278, the risk of such harm will not obtain, for example, where it's argued the expulsion will breach the person's right to respect for his or her private and family life. Situation envisaged in paragraph 83 of the D'Souza Ribeiro, and then that's set out. We've seen that already. And then 279 says similar considerations apply when an applicant alleges the expulsion procedure was collective in nature, the breach of an express convention, prohibition of collective expulsion. And the statement of principle in the second half of 279 is it follows that in such cases the Convention does not impose an absolute obligation on a state to guarantee an automatically suspensive remedy, but merely requires that the person concerned should have an effective possibility of challenging the expulsion decision by having a sufficiently thorough examination of his or her complaints carried out by the independent and impartial domestic forum. Court finds that the aggregento justice of the peace satisfied this requirement. So what's happening here is that there is a hearing made back through the report in front of the aggregento justice of the peace, examining the lawfulness and proportionality of the expulsion. And 280 explains that Mr. D'Souza Ribeiro didn't win because he successfully alleged a breach of Article 13 because of the absence of an automatically suspensive remedy, but because of the timing of the removal, and that's what 280 is concerned with. 281 follows that the lack of suspensive effective removal decision does not of itself constitute a violation of Article 13 of the Convention, whereas in the present case, the applicants do not allege there's a real risk of a violation of the rights guaranteed by Articles 2 or 3. So, once again, the fundamental point from our perspective is that there is no finding that the procedural safeguards examining the expulsion before it took place were unfair. And that's precisely what we say in paragraph 11A of our supplementary printed case at 6656. We refer to statements in those two cases, and we go on to say, not to say that Article 8 can never require a remedy with suspensive effect, where such a remedy will be necessary to safeguard the effectiveness and fairness of the appellate process. And we go on in C of that paragraph to say that nothing in either of those cases suggests a standard of protection lower than the line of cases beginning with W would be appropriate. For instance, the W line of authority envisages that the court looks at the decision-making process seen as a whole. CF D'Souza Ribeiro, paragraph 79, the aggregate of the remedies, however worded, the appropriate standard of protection will be the same. Those are the submissions on the two cases that are at the heart of the Secretary of State's attempt to draw a line between Article 6 and Article 8. In paragraph 15 of the supplementary case, we refer to cases which have applied the W and United Kingdom line of authorities in a precise immigration context. First of them is Silitz against the Netherlands, which is at Authorities Bundle 13, 153. I don't think I need to go to that. It's given you the references. It cites W in a precise immigration context. My submission is inconsistent with Malone Friend's analysis. The same is true of Senigo Longue in France, referred to in 15b of our printed case. I think the submissions that we make in 16, 17 and 18 of the supplementary case are ones that I've made already. Finally, on the matter of procedural fairness, there are in front of the court a number of judicial comments about the unsatisfactory nature of out-of-country appeals, and I would ask the court to bear those in mind. They go back a long way. They go back as far as Lord Fraser in Kira and Kawaja, which your lordships and my lady will find at bundle 3 of the authorities bundle. It's a very short dicta. Tab 40. Manuscript memory stick number 685.
Thank you.
Actually, the passage starts at 865. Passage starts at 864. This is the case which held that the issue of whether or not someone was an illegal entrant raised an issue of precedent fact. And there was a comment about out-of-country appeals at page just below letter H on memory stick number 864. It must be remembered that in spite of the court's decision affirming that of an immigration officer the illegal entrant be removed from this country, it would still be open to him to appeal under section 16 of the 71 Act to an adjudicator against the decision to remove him. The fact that he is not entitled to appeal so long as in this country, 16.2, places him at a serious disadvantage, but I do not think it's proper to regard the right of appeal as worthless. At least the possibility remains that there may be cases, rare perhaps, where an appeal to an adjudicator might still succeed. And then in BA Nigeria, bundle 9, MS 3124. Tab 94 or tab 9. We are in the judgment given by Lord Justice Sedley, paragraph 21, 3124. through the paragraph, about 4 lines into the paragraph, Miss Lang, who appeared for the Secretary of State, was said to be right to say that BA had no right to remain here while he attempts to establish his case before the EAIT, asked whether there was any discretionary provision, there was nothing in the Act or the rules, for allowing a removed appellant to return for the purpose of giving evidence in support of his own appeal. Ms Lang was unable to assist. The fact is that, especially but not only where credibility is an issue, the pursuit of an appeal from outside the United Kingdom has a degree of unreality about it. Such appeals have been known to succeed, but in the rarest of cases. The reason why the Home Office is insistent on removal pending appeal, wherever the law permits it, is that in the great majority of cases it's the end of the appeal.
Really, that's an encapsulation of your submission. You say the idea that you're going to run an appeal of this kind successfully out of country by a written statement, the idea that video conferences can be available, the idea that you're going to get a witness summons which is going to bring you back to the UK is illusory.
Yes.
That's your submission.
Yeah, absolutely. Yes, and therefore the certification procedure has to proceed on the basis that there will be an appeal hearing, if there's any appeal hearing at all, it will be an appeal hearing at which the appellant isn't present and isn't having any live input. Going on, Russia is at 10. Hang on a sec, I'm getting myself. Yep, I've got it. Is at 10.105. Authority starts at MS 3267. Paragraph 43 is at MS 3278. And we are in the judgment of Lord Justice Sullivan. I can get there. Paragraph 41. Sorry, paragraph 43, I don't know why I said 41. 43, I endorse the view expressed by Mr. Justice Collins, a former president of the Immigration and Asylum Tribunal in MK at first instance, that common sense indicates that a claimant who has to pursue an appeal while he's out of the country faces considerable disadvantages, particularly in the context of an appeal to SIAC, paragraph 29 above. The handicaps under which claimants labour in SIAC are well established. Parliament has authorised a procedure which deprives claimants in SIAC of a fundamental right to see the whole of the case against them, to which they would otherwise be entitled as a matter of fairness under the common law, CW Algeria. In this procedural context, the court should be vigilant to ensure that claimants in SIAC are not further disadvantaged by a failure on the respondent's part to comply with the rules. Applies with particular force in the present case where the allegations of the claimants were very grave indeed, and the respondent's case was not disclosed until a very late stage. So, stopping there, we have Lord Justice Sullivan, who I think at this stage was the president of the tribunal system, endorsing the views of Mr. Justice Collins, who's a former president of the tribunal system, about the effectiveness of out-of-country appeals. And then we have, finally, in this, Georgiou, which is at 111. Tab 137 starts at MS 3917. The passage is paragraph 22.4 at 3918. Pick it up. If we start on 3917, just to get the context, paragraph 21 refers to Kiarie. Then in paragraph 22 refers to a number of points of distinction between Kiarie and the present case and Mr. Georgiou's case, because Mr. Georgiou's case was an EEA case. And no doubt various points of EU law will point against certification, which is what Mr. Justice Blake is saying in 22(1), 2 and 3. But over the page at 4, he makes a point which applies in the present case. 4. In cases where the central issue is whether the offender has been sufficiently been rehabilitated to diminish the risk to the public from his behaviour, the experience of immigration judges has been that hearing and seeing the offender give live evidence and the enhanced ability to assess the sincerity of that evidence and is an important part of the fact-finding process. See, for example, the observations of this tribunal as to the benefits of having heard the offender in Massi, Pakistan, and see also Lord Bingham in Huang at paragraph 15. I think that's the closest I can come to answering my Lord Carnworth's question about input from the tribunal. We do have a fairly strong body of experienced members of the tribunal, amongst other things, expressing views about the value of live evidence.
I was looking back at the case of Chilis in the Netherlands, which you referred to, but
yes.
It's actually quite an interesting example of the Strasbourg courts in a particular case saying how he was deprived of the very important part of his ability to present his case by
being removed from contact, essentially, yes. Yeah, I mean, and we built on that partly in relation to what one can see as a separate heading under equality of arms. The Secretary of State makes a decision to remove us from the UK, and that deprives us of a chance of developing part of our case. But I'm not going to develop that line orally, given time, but that is in play. So those, I think, are my submissions on the procedural aspects of the case. These two other matters. The first is proportionality, which, as I promised, I can do by simply referring to our printed case. And if we look at the core volume, memory stick number 6587, we should have paragraph 7b of the case. And which sets out our basic submission on proportionality. Public interest supportive removal pending an appeal against the deportation order is different to and weaker than the public interest in support of deportation following final determination of any such appeal. Public interest is fed by two legislative goals, namely goals of speeding up and preventing abuse of the appellate process. Neither of these goals would be met in the circumstances of these appeals or indeed in many others. Consequently, the Secretary of State would ordinarily be required to point to something additional that can be said to positively require the removal of the appellant pending his or her appeal. It's likely to be an exceptional case where the Secretary of State will be able to justify action of this kind. And that description of the goals is justified, we submit, by reference to paragraphs 12 to 22 of our printed case, MS 6590 through to 6593. Which refer to what would be in European litigation called the TRAVO, the impact assessment, and various statements made in the Bill Committee. I won't read them, we just say at the end in paragraph 22, it will be seen from those passages that the twin and linked rationales for the introduction of section 94B of the Act together with the other changes to appeal rights, were A, to prevent delay and otherwise speed up the determination of human rights appeals, and thereby the removal of unsuccessful applicants, and B, to prevent abuse of the appellate system, defined as the use of an appeal as a delaying tactic, through which the appellant might build up some further claim to settle life in the UK. And then if we move on to the later in the printed case, 6647, we carry out in the text an exercise addressed at Bank Mellat and Lord Sumption's and Lord Reed's summary of the proportionality exercise. The critical and short submission, but important, is that made in paragraph 203, 6648. In the light of the preceding analysis concerning the purpose of 694B and the public interest underlying its introduction, it will be clear that steps 2 and 3 above are engaged, given that neither of the two aims of section 94B, speed and prevention of abuse, can properly be engaged be regarded as engaged in the appellant's case. It's not possible to say there's any rational connection between the measure of removal and the objective. On the evidence, out-of-country appeals take significantly longer to complete than in-country appeals. Indeed, delay is built into the process itself. There can be no question of any sort of abuse of the appellate system in the appellate's case. Any delay in the determination of appeal would not, in fact, substantially alter the basis of that appeal, which is predicated on the appellant having spent his childhood in the UK. Even if that's not right, apparently significantly less intrusive measures exist to meet the objectives of the Act without unacceptably compromising them. On the evidence, the appellant's appeal can be dealt with more swiftly if he remains in the UK.
I wonder if you're not overstating things to say that there's no rational connection between the objective. The objective is in the Travo, paragraph 18 of your case.
Yep.
6591 starts off to help speed up the deportation of harmful individuals. Now, it does that. And what is said on the other side is a person with your client's record is deemed to be undesirable here. He's undesirable even if actually he ends up having a right to stay here. There is therefore a public interest in securing his removal at the earliest possible opportunity. I wonder therefore whether to say that there is no connection with that objective isn't going a little too far.
I see that argument, but that only goes to demonstrate that the overstatement is in no rational connection. It doesn't assist very much, in my respectful submission, with the proportionality analysis, because at the end of the day you have to justify what will be a temporary absence, which has all the disruptive effects on private life and family life, in a context where you, the Secretary of State, have indicated you may come back. But I'm not going to argue.
You say the goals, in paragraph 7b, you've said the goals were speeding up and preventing abuse of the appellate process.
Yes.
Rather than speeding up deportation of undesirables.
Yes.
But do you accept that speeding up deportation of undesirables is one of the goals?
No.
Well, even though the Minister of State says so in your paragraph 18.
Okay. I think the truth is I'm agnostic as to whether it's a goal or not, because you could never justify, my fallback submission is you could never justify the removal of someone like my client for a temporary basis simply on the desirability of removing foreign criminals. If there was an overwhelming public safety issue, then it might be different, as we say in the printed case, but that's not the way it's put. It's not said that he must go now because of the immediate imminence of criminal offences. Just one final point on this. The guidance reinforces that perspective. If I can just ask the court to look very shortly at tab 2, bundle 2, tab 26, MS 458.
Sorry, give me that again, page.
MS 458, it's Authorities Volume 2, tab 26.
And it is obviously
And it
guidance.
is the December 2016 guidance. The original guidance was, of course, found to be faulty by the Court of Appeal. And the structure of this is in the second paragraph. The guidance says, when considering whether removal pending appeal will breach human rights, you should approach this question on the basis that the claimant's appeal will succeed, such that the removal will be temporary. You should consider whether serious irreversible harm or other breach of human rights will be caused by the temporary removal from the UK. So the express instruction to immigration officers is think of this as a temporary basis. The sort of exercise that is being called for is described at MS 460. So a whole series of bullet points are set out which are said not to justify a refusal to certify, or put it positively, examples where certification may be appropriate. First bullet point, the mere fact that a claimant will be separated from their partner for a period of time while appealing against the decision of refusal of a human rights claim. The parent of a child in the UK, no current subsisting relationship with their child, even though the court case in process. Lordships and my lady can see the sort of points.
We have reached a particular...
We have indeed.
I'm not sure whether that's a convenient moment.
But that's the end of all I want to say about proportionality. I've got one topic, I've got 10 minutes to deal with it, which is whether it's Connors and Pinnock or ordinary judicial review, but I'll do that in 10 minutes and between 2 and 10 past, if that's acceptable.
Well, we'll look forward to hearing from you at 2 o'clock then. Court is now adjourned.